You are 68 years old. You have owned a firearm for over 4 decades. You've never been arrested, never been charged with a crime, never threatened a single soul. And then one Tuesday morning, there is a knock at your door. Law enforcement is standing on your porch, not to ask questions, but to take your guns. No trial, no criminal charge, just a piece of paper signed by a judge you've never met. This is not a hypothetical. In 2026, this is already happening across America. Let me be very clear about something right from the start. This channel does not deal in fear for the sake of fear. We deal in facts. And the facts surrounding what is happening to senior gun owners in 2026 are genuinely alarming, not because someone made them up, but precisely because no one is talking about them clearly enough. You've probably heard the term red flag laws thrown around on cable news. Politicians on both sides argue about them constantly. But here's what the talking heads almost never tell you. They never zoom in on who these laws are actually affecting in real life. They never tell you that the demographic most vulnerable to losing their firearms without warning, without a criminal charge, and without a fair fight is senior citizens over the age of 65. Today, we are going to change that. We are going to break down exactly what is happening in 2026, which states are expanding these laws, why seniors specifically are being placed in the crosshairs, and most importantly, what you or your loved ones need to know right now to protect your constitutional rights. Stay with me all the way through this video, because the second half contains information that could directly impact whether you keep your firearm or lose it. What are red flag laws, really? Before we get into the senior-specific angle, you need to fully understand the mechanism at work here. Because the name red flag law sounds almost reasonable, doesn't it? It sounds like something that catches dangerous people before they do something terrible. And that is exactly how it was sold to the public. Here is how it actually works. Red flag laws, formerly called Extreme Risk Protection Orders, or ERPOs, allow certain people to go to a court and petition a judge to temporarily seize your firearms. The people who can file this petition vary by state. But in many states, that list now includes law enforcement officers, family members, household members, healthcare providers, teachers, school administrators, and even co-workers. Here's the part they don't put in the brochure. In some states, the person who is the subject of a red flag order may have no knowledge of the petition before it is approved. As a result, there is no opportunity to defend against the accusation before property is confiscated and the right to purchase or possess firearms is restricted. Read that again. You may not know this is happening until law enforcement is already at your door. ERPOs are ex parte, meaning that the court does not need the individual's permission to remove their weapons. This is the legal term that every gun-owning American needs to understand. Ex parte means one side. One side presents evidence to a judge. Your side is not in the room. Your side doesn't get to speak. And a decision is made that strips you of your Second Amendment rights before you ever had a chance to say a single word in your own defense. When a red flag order is issued, the process can move quickly. In some cases, it may begin before you're even aware it's happening. After a family member, law enforcement officer, or other authorized individual files a petition, a judge will review the request and possibly issue a temporary order. And just like that, decades of legal, responsible gun ownership can be erased overnight. The 2026 expansion, it's getting wider. Now here is where things in 2026 escalate significantly, and this is where senior Americans need to pay very close attention. Red flag laws are not new. Connecticut first enacted one back in 1999, but what is new is the pace and scope of expansion happening right now. Some states are expanding the use of extreme risk protection orders, or so-called red flag laws. These laws allow courts to temporarily prohibit firearm possession if a person is determined to pose a significant risk to themselves or others. As of right now, 22 states and Washington, D.C. have active red flag laws on the books. But the expansion is happening on two fronts simultaneously, and both of them are dangerous for seniors. Front number one, more states are adding these laws. Maine recently put a new ERPO system in place. Other states are actively debating similar legislation right now in their 2026 legislative sessions. Front number two, and this one is perhaps more alarming. States that already have these laws are expanding who can file the petition against you. Let's use New York as an example. New York expanded. Who may file an ERPO petition to include healthcare practitioners who've examined an individual within the last 6 months, and requires police and district attorneys to file ERPO petitions. when they have credible information that an individual is likely to engage in conduct resulting in serious harm. Think about what that means in practice. Your doctor, the physician you trust with your most private health information, they can now petition a court to take your guns. And in certain states, they may be legally required to report concerns. Even if you believe the conversation was entirely confidential, in Hawaii, the list of who can petition is even broader. Police, family or household members, healthcare providers, teachers, and colleagues can all apply to the courts to have an individual's weapons temporarily confiscated. And at the federal level, things aren't sitting still either. A prominent federal proposal in 2026, described as the Virginia Plan to Reduce Gun Violence Act of 2026, would bundle an assault weapons ban, expanded red flag authorities, and national standards on purchase and storage. A federal red flag law with expanded authorities, that is what is being proposed right now in Washington. Why seniors are the most vulnerable. Now we get to the core of what makes this situation uniquely dangerous for Americans over 65, because the law doesn't say this applies to seniors. It is written to appear neutral. But the way it operates in the real world, the triggers, the petitioners, the standards, they converge in a way that puts older Americans at disproportionate risk. Here is why. Reason 1. Cognitive health concerns. As Americans age, normal and completely benign changes in memory, mood, or behavior can be misinterpreted by family members or healthcare providers as signs of danger. An elderly man who becomes more irritable after a health diagnosis. A grandmother who talks about not wanting to be a burden anymore. A senior who has always been outspoken about protecting his home and his family. Any of these situations could, and in some states already have, triggered an ERPO filing by a concerned family member or a doctor who heard something in a routine checkup that made them uncomfortable. Red flag laws are triggered based on statements, behaviors, or actions indicating potential risks. Statements and behaviors. That is an extraordinarily broad standard. And when you are dealing with an elderly individual who may be processing grief or managing chronic pain or simply expressing frustration, that standard can be weaponized with devastating consequences. Reason 2, the VA fiduciary loophole. For millions of American veterans, many of them seniors, there was a specific threat that existed within the Department of Veterans Affairs system for years. Veterans who needed help managing their finances due to age or disability could be assigned a fiduciary by the VA, and historically, being assigned a VA fiduciary could trigger a report to the Federal Prohibited Persons Database, meaning veterans could lose their gun rights simply because they needed financial help. The good news, and this is genuinely good news, is that a federal appropriations package passed in late 2025 includes provisions protecting veterans' firearms rights by requiring additional due process before the Department of Veterans Affairs may report a veteran with a fiduciary to the Federal Prohibited Persons System. That protection is now in place. But veterans still need to understand the landscape because the VA fiduciary threat may have been addressed at the federal level, while state-level red flag mechanisms remain a completely separate and active risk. Reason 3, family dynamics. This one is painful to talk about, but it needs to be said. Not every family is a united front. Sometimes the threat to a senior's gun rights doesn't come from the government. It comes from within the household. Adult children who don't like the fact that their elderly parent still owns a firearm. A contentious family situation involving inheritance, care decisions, or guardianship disputes. A domestic conflict between spouses where one partner decides to use the ERPO system as leverage. Family members, including spouse, domestic partner, parents, children, siblings, grandparents, grandchildren, nieces, nephews, uncles, aunts, and half-siblings can seek an order to remove firearms. That list covers virtually every person in your family, and once that petition is filed, once that judge signs that temporary order, the person also loses any concealed carry permits he or she may have, and is prohibited from purchasing or possessing firearms, typically for up to 1 year. One conversation, one petition, one judge's signature, and a year of your gun rights gone. Mid-video CTA. Before we go further, if this information is as serious as it sounds to you, do your fellow gun owners a favor. Hit that subscribe button right now and ring the bell for notifications. We cover the gun law stories that mainstream media won't go near. And if you know a senior gun owner, a parent, a grandparent, a veteran, a neighbor, share this video with them today. This is the kind of information that protects families. Now let's keep going. What happens after the knock on your door? Let's walk through the actual sequence of events when an ERPO is filed against you, because understanding the process is the first step to knowing how to fight it. Step 1. Someone files a petition, they go to the courthouse, fill out forms at no cost, and present their case to a judge. You are not there, you don't know this is happening. Step 2. The judge reviews the petition in what is called an ex parte hearing. If the judge determines there is sufficient cause, they issue a temporary ERPO. This can happen the same day the petition is filed. Step 3. Law enforcement is dispatched to serve the order and collect your firearms. If any firearms or ammunition were not turned in as a result of a temporary ERPO, the police can collect them. In some states, you have as little as 24 hours to surrender your weapons to a licensed dealer or law enforcement after being served. Step 4. A follow-up court hearing is typically scheduled within 14 days. This is your first opportunity to actually speak in your own defense, but your guns are already gone. Step 5. If the court issues a 1-year order, even after a favorable outcome, you will need to follow up to ensure records are updated and your firearms rights and permits are fully restored. Even if you win, even if the judge ultimately rules in your favor, there is no guarantee your records are automatically cleared. You have to chase it down yourself. For a 70-year-old dealing with the emotional trauma of having their firearms seized, navigating court bureaucracy is not a simple task. And here is something that rarely gets discussed. What happens to the guns while they are in custody? In subsequent hearings of cases not dismissed, the court ordered the destruction of the firearms in 72% of cases when the individual did not appear in court. 72%. If you don't show up, whether because you weren't notified properly, because you have a health issue, because you simply didn't understand the legal process, your firearms can be destroyed permanently. The state's pushing back. Now, here's the side of this story that deserves equal attention because it is critically important and it gives gun owners something to rally behind. Not everyone in America is rolling over for this. A growing number of states are fighting back against ERPO laws in a serious and aggressive way. Bans passed by Montana and Texas in 2025 and by Wyoming in 2026 impose consequences on officials who enforce ERPOs, including those issued by other states. In Montana, the state can fine local governments up to $10,000 per violation. Think about that. Montana is fining governments that try to enforce these orders. And that is a state government standing up and saying, we will not allow this process to operate on our soil. Wyoming went further. In Wyoming, running afoul of the ban can earn someone as much as a year in prison, a $2,000 fine, or both. And then there is Texas. Texas' ban goes furthest. It makes enforcing or serving an ERPO a felony, punishable by up to 2 years in prison. A felony. For a law enforcement officer who tries to serve an ERPO in Texas, that is now a criminal act. Proposals in Iowa and Missouri prescribe $50,000 fines for violations. South Carolina's bill, dubbed the Ban Against Red Flag Gun Confiscation Act, would make enforcement a felony. These states are not messing around. And this is not just political posturing. These are legally binding consequences designed to make ERPO enforcement functionally impossible within their borders. So if you are a gun-owning senior in Texas, Wyoming, or Montana, you are in a meaningfully different legal position than a senior in New York, California, or Hawaii. Your state government has made a deliberate choice to stand between you and this process. But if you are in one of the 22 states where red flag laws are active and expanding, you need to understand that your state has made the opposite choice. What you need to do right now, this is the section that matters most, because information without action is just anxiety. So let's talk about what gun-owning seniors and their families can practically do to protect their rights in 2026. Step 1, know your state's law. The single most important thing you can do today is find out exactly what the law says in your specific state. Does your state have an active red flag law? Who can petition in your state? What is the evidence standard, probable cause, or something higher? Knowing your legal landscape is step 1. Step 2, have the family conversation. This is uncomfortable but necessary. If you have adult children or family members who have concerns about your firearm ownership, have an honest, open conversation before it reaches a courtroom. Many ERPO cases are filed by family members who are worried but didn't know how to have a direct conversation. Get ahead of it. Let the people closest to you understand your intent, your training, and your responsibility as a gun owner. Step 3, establish a relationship with a Second Amendment attorney. You do not need to be in crisis to need a lawyer. Every serious gun owner, especially seniors, should know the name and phone number of a Second Amendment attorney in their state before anything happens. Organizations like the United States Concealed Carry Association, Gun Owners of America, and state-level firearms organizations often maintain legal referral networks to use them. Step 4. Document your responsible ownership. Keep records of your firearms training. Keep records of your safe storage setup. If you have a concealed carry permit, keep it current. If you take a safety or self-defense course, keep the certificate. This documentation matters if you ever need to demonstrate in a court of law that you are a responsible, informed gun owner. Step 5. Be careful what you say to your doctor. This one may feel unsettling, because it is. But in states where healthcare providers can file ERPO petitions, your routine medical conversations now carry a legal dimension they did not have before. That does not mean you should lie to your doctor. It means you should be aware that anything you say about frustration, hopelessness, or any language that could be interpreted as risk-related may be treated as a legal trigger in certain states. You have a right to ask your doctor about their reporting obligations before you speak. The bigger picture. Let's step back for just a moment and look at what is happening from 30,000 feet, because the senior gun owner issue is not happening in isolation. 2026 is shaping up to be one of the most consequential years for Second Amendment law in recent memory. Gun laws change frequently, and 2026 is shaping up to be another important year for firearm legislation across the United States. Several states are considering new restrictions on semi-automatic firearms, magazine capacity, and ammunition access. At the same time, there are genuine wins for gun owners on the federal level. Congress passed the One Big Beautiful Bill Act, which included provisions affecting firearms, including removing suppressors from certain federal regulatory requirements and reducing associated tax and compliance burdens. So the picture is complicated. There are attacks on gun rights in blue states and in federal proposals. There are protections being strengthened in red states. And in the middle of all of this, real, law-abiding Americans, many of them seniors, are trying to understand what their rights actually are on any given Tuesday morning. The answer is, it depends heavily on where you live. That is the uncomfortable truth of American gun law in 2026. Your Second Amendment rights, the same amendment, written in the same Constitution that covers all 330 million Americans, are enforced completely differently depending on which side of a state line you happen to be standing on. A 70-year-old veteran in Montana has more practical firearms protection today than a 70-year-old veteran in California. Not because the Constitution changed, but because the states have made radically different choices. And that is something every American who cares about this issue should find deeply troubling, regardless of where they happen to live. Here's what it comes down to. You earned your rights. You have lived them for decades, and you should not have to lose them silently without warning, without a hearing, without a voice because of a law that most Americans still don't fully understand. The best weapon you have right now is information. Share this video, talk to your family, know your state's law, find your attorney before you need one. The people who want to dismantle the Second Amendment are counting on gun owners staying quiet and staying uninformed. That is the one thing we will never do on this channel. If this video opened your eyes, subscribe right now, because there is more coming. Laws are moving fast, rights are on the line, and seniors across this country deserve to know exactly where they stand. Don't stay silent. Stay armed, stay informed.